Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about Indigenous rights in appeals. Cases that should have gone to the Supreme Court of Canada, but didn't. Tim Etcheluk was convicted of a number of sexual assault offenses after he, while he was intoxicated, engaged in some non-consensual touching of women on the street. He pled guilty to those offenses and was sentenced, and then appealed his sentence, arguing ineffective assistance of his lawyer. Essentially, what Mr. Etcheluk was saying was that his lawyer had not advised him about the opportunities and options available to him as an Indigenous person in asking for a certain sentence, and had not advised him about the content of a sexual assault plea that included certain records and registries that he had to become a member of. As a result of his appeal, the Court of Appeal had the opportunity to consider whether or not a person's Indigenous status and Indigenous rights had an impact on how an appeal is to be determined. So whether or not, as an Indigenous person, Mr. Etcheluk was entitled to some different procedure or different examination of the evidence and the decision on appeal. The Court of Appeal ultimately determined that there was no incompetence of counsel, and Mr. Etcheluk sought leave to appeal to the Supreme Court of Canada, which was dismissed. This decision is particularly disappointing because the role of Indigenous people and their lawyers is one of the many ways in which Indigenous people in this country have been at a disadvantage. Historical studies have shown that Indigenous people spend significantly less time in communication with their lawyer prior to plea deals compared to non-Indigenous individuals, that they receive fewer jail visits when they're held in custody than non-Indigenous individuals, and that they generally don't receive the same level of legal representation. The reasons for that are directly related to the impacts of colonization. And so when examining a plea that is contested on appeal, is the role of somebody's Indigenous status not something that should be considered by the court? Is that not directly related to whether or not the lawyer had adequate instructions and adequately informed their client? And if the studies do show that there are these discrepancies between how non-Indigenous people and Indigenous people are given legal services, how does that not play a role directly into the validity of appeals in these cases? This was a case where the Supreme Court of Canada had a huge opportunity to deal with a significant issue of discrimination and historical disadvantage in this country, and to set up good parameters so that lawyers know what they need to do when they're dealing with Indigenous clients, and ensure that they follow all the necessary steps in engaging their clients before entering a guilty plea and proceeding to sentencing. They had an opportunity to right a historical wrong, and they missed that opportunity. Unfortunately, this means it's going to take another case of another Indigenous individual being disadvantaged or alleging that they're disadvantaged before the court can ultimately deal with this issue. It's a disappointing move by the Supreme Court of Canada, and I hope the next time they have this opportunity, they seize upon it. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Brazen Bull Creative has been invaluable assistance in putting together these videos, and I encourage you to like, subscribe, share with your friends, and watch all the others.